Are we live?
Yes.
Thank you. On behalf of the Gender Fairness Committee of the Third Judicial District, the Permanent Commission on Justice for Children, our administrative judge, the Honorable Thomas A. Breslin, Albany Law School Dean Alicia Willett, and the Albany County Bar Association, I'd like to welcome you to Girls and Girls of Color in the Criminal Justice System. I'm Judge Rachel Kretzer, Chair of the Gender Fairness Committee and an adjunct professor at Albany Law. This program could not be more timely. Recent events require us to face the harsh reality that we still do not live in an equitable world. There's a heightened awareness of the need to address racial injustice in all its forms. And today we're going to examine racial and gender disparities in the juvenile justice system. Almost 300 judges and lawyers have registered for this, actually over 300 now, have registered for this program. So clearly it has touched a nerve and people understand that this is an issue whose time has come. Now, this is a first for the Gender Fairness Committee, a virtual CLE. And for this Technosaurus, it was a challenge. It's a tribute to the notion that necessity is the mother of invention. As many of you know, we had planned to do this live in April, and Albany Law School had graciously agreed to host us. COVID-19 intervened, dashed all those plans, and we paused for a moment, but we thought it was an important topic, and we didn't want to let it go. Thankfully, Marquita Rhodes, Executive Director of the Albany County Bar, has agreed, and she's the one who took the lead in making this program virtual. With the invaluable support of Dean Alicia Willett and the terrific folks at Albany Law School, the IT people, the events people, we have made it happen. So thank you, Dean Willett. Thank you, Marquita, and thank you, John Carr, Vice Chair of the Gender Fairness Committee, whose idea this was in the first place. A shout out to our co-sponsors. In addition to the Albany County Bar and Albany Law School, we have the Center for Women in Government, the Legal Project, the National Association of Women Judges, New York chapter, the Women's Bar Association of the State of New York, the Women in the Law section of the New York State Bar, the National Conference of State Trial Judges of the ABA, and the Capital District Women's Bar. There are 40 judges from all levels of our justice system registered for this program. So unfortunately, I can't try to recognize all of the prominent jurists who are with us today. But I would be remiss if I failed to mention Court of Appeals Judge Leslie Stein, who is a former chair of the Gender Fairness Committee and a current member of both the Gender Fairness Committee and the Commission on Justice for Children. And we also have Justice Beth Gary, presiding justice of the Third Department Appellate Division. So this afternoon, we're going to explore an emerging issue and one that really has not been widely considered or examined. We know that girls constitute the fastest growing segment of the juvenile justice system and now account for nearly 1/3 of juvenile arrests in the United States. We know that girls of color are 2.7 times more likely than their white counterparts to be referred to the legal system and 20% more likely to be formally petitioned. We know that girls of color are more than twice as likely as white girls to be detained. And I'm going to repeat that. Girls of color are more than twice as likely as white girls to be detained. We don't yet have a firm grasp on the obvious question, why? Why is this so? And what are we going to do about it? So this afternoon, we'll drill down into the issue, and with the help of our outstanding panelists, after an overview by retired presiding Justice Karen Peters, chair of the Judicial Commission on Justice for Children, will present two separate panels. First, our moderator, Kristen Ann Conklin, Executive Director of the Commission on Justice for Children, will moderate a discussion with two experts from NYU, Dr. Shabnam Javdani and Mackenzie Berezin, who have studied this issue extensively and who will share what I think you'll find to be some revealing and disturbing data. Then Kristen will moderate a discussion with our two judges, the Honorable Kathy Davidson, Administrative Judge for the 9th Judicial District, and one of the creators of the Gender Responsive Initiatives and Partnerships Court. Now that's a mouthful, but it's fondly known as the GRIP Court, and the Honorable Lisa Fisher, a Supreme Court Justice from Greene County, and a member of our committee. All of the panelists have impressive credentials, and their biographies are included in the online packet of materials. In the interest of time, I'm going to skip the formal introductions, but I really encourage you to read their impressive bios. I'm going to turn it over to Justice Peters in just a moment. But first, we have to deal with a couple of administrative chores. Please use the chat feature to report any technical issues. You can ask questions at any time, and our moderator, Kristen, will determine when those questions can be addressed. And please remember that this program is being recorded. And now it is my pleasure to recognize Justice Karen Peters, who has always been in the forefront of ensuring racial and gender equality. And incidentally, Justice Peters is also a former chair of the Gender Fairness Committee. And I think you'd all agree that with Judge Stein and Justice Peters preceding me, I have had big shoes to fill. Justice Peters.
Thank you, Judge Kretzer. And thank you, Albany Law School and the Albany County Bar Association for sponsoring this event today and inviting us to present on this very important issue. I also want to express my appreciation to all the sponsors. We're very glad to be here today, and we think the information you'll acquire will be of value to each and every one of you who are participating this afternoon. The work you're going to hear about was born from the New York State Girls' Justice Initiative, which was a collaboration led by the New York State Unified Court System and implemented by the New York State Permanent Judicial Commission on Justice for Children. But we partnered with NYU's Steinhardt School of Culture, Education, and Human Development, and the New York State Division of Criminal Justice Services. We like to partner. We think the outcome is often more valuable. The goal of this project was to address the documented criminalization of girls' behaviors, including those related to status offenses and technical violations of probation that too often reflected trauma-induced responses on behalf of the girls. We felt it important to understand the trauma-informed policies and programs for girls at risk or involved in the juvenile justice system that could provide services to them in a positive way. For those who might not know, the New York State Permanent Judicial Commission on Justice for Children was established in 1988 by Chief Judge Judith Kaye. Judge Kaye's passion, as she termed it, was her work to improve the lives of children and families in New York State. She raised the stature of the quintessentially important family court in a way no one else could ever do. She valued the work of the judges, the attorneys, the court personnel, and the many agencies and professional people that helped the court. The commission was her work and her passion. She said, as an interdisciplinary children's commission based in the judiciary, we've been able to harness the authority and prestige of the judiciary to launch and sustain projects and to shape policy that improve court proceedings and maximize the well-being of children in out-of-home care. We've enjoyed the incredible benefit of a largely constant, invariably outstanding interdisciplinary commission membership. Dedicated representatives from all three branches of government, from the bar and from fields such as medicine, social work, child development, education, and child advocacy. What unites us and what keeps us is the belief that we can improve the lives of children. And in fact, that is our mission at the Commission, to improve the lives and life chances of children involved in the New York State court system. To do that, we study the system of justice for children in the state and the network of support services in the health, education, and welfare field. We recommend relevant legislative, administrative, and other reforms. We currently have 40 members. We are led by the executive director, Kristen, who will be speaking later, and all members are appointed by the Chief Judge of the State of New York. Right now, we have 20 judges at all levels of the judiciary, from trial judges to Court of Appeals judges. The executive branch of government is well represented as well. We have commissioners and directors from many state agencies, the New York State Office of Children and Family Services, the Department of Health, the Office of Mental Health, the Division of Criminal Justice Services, and the New York City Administration for Children's Services. And petitioners are represented also via the Legal Aid Society, the Center for Family Court Representation, Lawyers for Children, district attorneys, and the director of the New York State Courts Attorney for Children program. So practitioners, judges, lawmakers, policymakers, they're all represented before our commission. The Girls' Justice Initiative, which led to the creation of the GRIP Court, as Judge Kretzer advised you, had three complementary components. The first was a research component. And if we've learned anything during this COVID pandemic, it is the extraordinary value of research and data collection. The second component was a local county level pilot to test preliminary policy. And the third was the development of a statewide plan. You're going to hear about all of those components today. When we began this journey, a key member of the GRIP court team said, "We have a responsibility to do this work." And I and the commission know full well at this point in time in our history, we have an even more significant responsibility to do this work. I believe at the conclusion of the presentation today, you will all know we have a responsibility to do this work. We hope you will join us in promoting healing, providing opportunities, justice, and support to improve outcomes for girls, and in particular, girls of color who are at risk in our juvenile justice system. I now turn the program over to the people who are going to give you the nuts and bolts of an extraordinary achievement.
Thank you very much, Justice Peters. At this time, I would like to just say that while a lot of what's going on has raised a lot of consciousness surrounding this issue, I want to point to Judge Davidson in particular and note that she and her team have been working on this particular issue for years. Our particular project goes back at least 3 years, if not longer. And the idea is to center the voices of women, girls, and youth. Because as you will see, we have been confining girls for their own safety and then charging them criminally for their behavior while in confinement. Before I turn it over to Dr. Jabdani and Ms. Berezin, I would note that what you'll learn from this is that girls, the takeaway hopefully that you will see is that girls need a system that is trauma-informed, gender responsive, culturally competent, and that they are given an opportunity to be heard. I reiterate Justice Peters' words about our Girls' Justice Initiative that helped kick off this work. And you'll hear more about it a little bit later. It combines the research, the court system, and the continuum of care that girls encounter within the juvenile justice system. And again, this is a longer version of our vision, but it's that all girls will encounter a system that is trauma-informed, gender responsive, culturally competent, and have the opportunity to be heard and have a voice within that system. With that, a lot goes into the training, which I'm going to have Dr. Jabdani and Ms. Berezin talk about, and then I'm going to revisit the issue of training later on with Judge Davidson. and in talking about our plans for the statewide vision. But what you see on the screen is some of the training that the Westchester team encountered. And with that, I will turn it over to Dr. Javdani, ask her to touch on the training, and then begin talking about the gendered pathways.
Great. Thank you so much, Kristen. It's an honor to be part of this panel. I agree. The presentation of this work could not be more timely, and I value so much the opportunity to speak with you all and share our data with you today. To take off from where Kristen left off, I just want to mention that one of the major parts of the GRIP initiative that Judge Davison will tell you about a little bit later began with creating a learning and knowledge sharing community. And part of what happened was understanding the lay of the land when it came to training, understanding what we needed to know and how we needed to reflect on and understand the work of the court as a response to girls, and how we could bring together folks who were already on the cutting edge of engagement, whose programs and practices had demonstrated effective responses for girls and their families, and also to include multiple different types of possibilities in the response to girls. And so that is why the slide that you just saw, the training slide that Kristen just showed, included many different bullets. There was not one single approach to training, and I think you will see why as we begin to paint a little bit of a more complex picture about sort of girls' needs, and are thinking about what the role of the court currently is in the lives of girls, and what the role of the court can be, and how the court can function to potentially support girls in community engagement, and have as little sort of more serious contact with girls as we can imagine. And so this is the array of training that we will talk about the specifics of in a while, but there are many different types of versions of training for folks who are interested in different ways of engaging with girls and their families. So let me take 1 minute to just point out some of the national trends that we see about girls and boys pathways into the juvenile legal system. This information may not be new to some of you, but essentially for years, data have been suggesting that although both boys and girls come to contact with the juvenile legal system with a history of mental health needs, a history of traumas, including experiencing adverse childhood experiences, or those ACEs, as well as identify as gender nonconforming or LGBTQIA youth. While that is true for boys and girls, girls experience a higher proportion of all of those different types of indicators. They display more mental health needs, more of them report sexual trauma histories, more of them report experiences of more than 5 adverse childhood experiences, including seeing violence in the community, parental conflict, neglect, and so on. And almost half of them I self-identify as gender nonconforming or LGBTQIA youth. That is a statistic that we did not have just a few years ago, but some research from Angela Irvine and others has demonstrated that we are disproportionately bringing to court and also confining girls of color who identify as LGBTQIA. That is the population of girls that by and large we are talking about when we talk about the court response to girls. And so our awareness and our understanding of the intersections of those multiple identities, and how then our services and systems respond to girls who identify as Black and Latina and who identify as LGBTQIA should really be at the heart of the conversation about how to create a response that is effective for girls.
Dr. Javdani, if I can interrupt for 1 second, we have a question about these particular stats. Are these just reflective of girls and boys of color?
No, these are all girls and boys who have contact with the legal system.
Thank you.
Great. Thank you. As was mentioned already today, we know that girls are a growing proportion of arrests nationally compared to boys. Even though there are fewer total number of girls arrests, their proportion of arrests for girls are growing and are growing in all different categories, including violent offenses. Despite that trend and despite the consistency of that trend for almost a decade now, still only 6% of all programs available at the national level are designed specifically for girls and with attention to their needs. That is according to the Office of Juvenile Justice and Delinquency Prevention. However, a separate meta-analysis or big picture systematic analysis of all published studies of all kinds of programs that could serve youth who have needs that would bring them into the legal system examined the effectiveness of all available programs by gender and found two things. One, boys benefit from available programs much more compared to girls. So this is the sample of evidence-based programs. So programs that have been supported enough, have been thought through and manualized often with enough specificity that they can be published, that they can be disseminated to stakeholders across jurisdictions. These are programs that when you look at it by gender, and this was the first study to do so, we find that their effects are stronger for boys compared to girls. And in particular, group format interventions were particularly unbeneficial for girls, despite the fact that they were the most popular type of program offered to girls. So the national landscape suggests that simply referring a girl to an evidence-based program, even if it's a gold standard program, is not in line with setting that child up for success, given what we know. And this is across, I believe, over 50,000 youth across all 50 states that this study was conducted. That does not mean that we're setting up those kids for success in ways that we might think that we are, and in ways that we, in fact, might be, or at least be doing more so for boys compared to girls.
Just ask a quick question as we move to the next slide. There was a question about what ACEs are that we referred to on the last slide. If you could briefly tell us that while we move to the next one.
Yeah, no problem. ACEs stand for Adverse Childhood Experiences, and they come from the medical literature. And there is a particular survey that lists 10 different adverse childhood experiences, and data for years has demonstrated that having 5 or more and then 7 or more ACEs is associated with all kinds of very serious health and mental health related disparities. Great. Okay, so this brings us to an overview of the data analyses that we conducted in Westchester County. And I must start this section by first of all saying that as a researcher, as an applied researcher who has been doing this work for 15 years, focusing specifically on gender and juvenile justice, this set of data is among the richest that I have been able to encounter and have the privilege of analyzing in my career, specifically with respect to what it tells us about what's happening at the level of petition for boys and girls. And having this type of data transparency is indeed one of the recommendations that I think will come out of this initiative, and has from other initiatives as well, because it can tell us so much about what the experience of kids might be in the particular way that we would like to understand them. In this case, we're doing a gender analysis, and I'll tell you all of the information that we have as well on race. But I just want to underscore that petition level data for an entire county, the entire population of petitions from January 2016 through June 2017 were made available to us. And that is really a testament of the partnership between the commission, between Judge Davidson and all of the partners in Westchester County, as well as between all of the partners that were part of this particular grant. But that I think that data transparency is part of the initiative to support racial and gender equity, especially when it comes to the types of data that are neither publicly available nor are they easily available outside of the context of partnerships and relationship building. So with that said, we took a look at all of the petitions filed in Westchester County during the dates that I mentioned, and we were able to look at both the juvenile delinquency and the status offense petitions filed as separate groups. That we had two overall purposes, and that was to identify specific pathways driving girls' court involvement in this county and how that might differ from boys, and to identify alternative community and court-based programs that could effectively divert girls from system involvement based on these pathways. That second purpose is really around the response of this initiative, which Judge Davidson will have more to say about in the later part of this panel. I will be telling you about the first. And so let's begin with looking at our petition sample overall. Here we had 842 petitions. As you can see, about 42% of these petitions across PINS and JD were for girls, whereas 58% were for boys. You can see them broken down here by JD initial and supplemental, where boys are overly represented, versus PINS initial and PINS supplemental, where girls are more represented. This more or less mirrors the national trends, although we see more representation for girls in both PINS and JD compared to the national sample. And I think that we would find this in many counties and jurisdictions that we looked at, that we would look at in New York State as well. So girls are an even greater consumer of the legal system, of the juvenile legal system, I believe, in this county, and I believe in New York State compared to national.
Just so the attendees are aware, I'm going to ask some of the questions. I am monitoring the questions as they come in, and some of them I will ask along the way, and some I will save to the end. But we did just get a question as I move to the next slide. If you could talk about how you're defining boys and girls. Is that sex assigned at birth, or how is that defined for you in this study?
That's a great question. Thank you. In this particular study, because we have only court documents, it is defined by the particular box checked on the particular petition and or the identified, the way that a petitioner is identifying that child. So it is not about gender identity at all. It really is about the gender identified by stakeholders or petitioners.
And one follow-up, can you just explain what you mean between initial petition and supplemental petition?
Sure. The initial petitions are always the first petitions to be filed, which is what we're going to talk about most here in this presentation. And the supplementals are if another petition was filed following that initial petition. So the supplemental land is where we are looking now to understand the lay of the land for technical violations. For instance, if a youth violated the terms set based on what followed the initial petition, and a supplemental petition was filed, effectively extending court involvement in some way. Great. Okay, and here you can see broken down just across supplemental and initial here. See the pattern clearly. Girls are representing almost 2/3 of the PINS petitions compared to boys about 1/3, and the pattern essentially reverses, where boys are about 2/3 of juvenile delinquency petitions compared to girls. Not surprising here. Now, when we look at it in a little bit of a different way, we see, and we look at petition type by gender, we see that for girls, about half of them are receiving PINS petitions and half of girls are receiving juvenile delinquency petitions. Whereas when you look at individual boys, only about 1/3, a little less than 1/3, are ever receiving a PINS petition, whereas the majority of boys who are being petitioned for a juvenile delinquency petition, both initially and supplementarily. Great. And here's our race and ethnicity breakdown. And we were definitely hoping to extract as much race and ethnicity information from these petition files as we possibly could. And let me just first say that for the PINS petitions, no information on race and ethnicity was systematically available here. That is an important gap to address with respect to data collection across counties and thinking through the systems that we have in place for documenting data on youth, ideally self-identified race and ethnicity, but even petitioner identified race and ethnicity, which we have here for juvenile delinquency petitions, we do not have for PINS petitions. On the left side, you see for juvenile delinquency petitions, a breakdown of race and ethnicity, including cases where we were missing data, which from the purple chunk of that pie, you can see it was missing for about a quarter of the data. And then you can see that 5% of youth were identified by petitioners as white, whereas 70%, again, removing that 25% that were missing, were identified as youth of color, primarily as Black, African American, Hispanic, or Latino. If you exclude the data that we were missing and you look at the percentages in a little bit of a different way, you can see that essentially 94% of youth whose ethnicities and race were known are youth of color, whereas 6% of youth are white.
It's being noted in the Q&As that that information is not on the form petitions. Is it fair to say that that's a recommendation that you have?
Thank you so much. Yes, absolutely. And where we got this information was by systematically coding the police reports that were attached to the juvenile delinquency petitions. And so you could argue that without the partnership and the infrastructure and the support of the grant, it would have been the race and ethnicity of juvenile delinquency petitions would have been, may have remained not transparent as well, because we have to systematically gather them from the police reports. So with respect to the juvenile delinquency petitions, we had a couple of research questions going in, and those are, what are the types of allegations filed against youth, and how do these allegations differ by gender? And then do the frequency, type, and severity of delinquency petitions filed against youth in residential treatment establishments or residential treatment facilities differ by gender? This second research question really came about because of very informative conversations with the group of stakeholders led by Judge Davidson in Westchester County, who had noted doing their work that the residential treatment facilities were places where they knew work on behalf of girls had to be done. And so we knew that with the petition data, we could look and see within the population of youth, boys and girls, residing in these residential treatment facilities, what was happening. And what did that mean in terms of the response of the system to those youth? Great. So this is for all youth in that 18-month period who received a juvenile delinquency allegation. What was it for? You see here that by and large, boys represented by those gray lines are coming in for crimes like attempted assault, sexual offenses, criminal mischief, minor offenses, robbery, possession of a weapon, and other delinquency acts, more so than girls. And girls, and Kristen, would you go to the next slide? Girls are disproportionately coming in for the category of simple assault for juvenile delinquency offenses. Some of the research literature has found this same pattern when they've looked at smaller subsamples here and there. But this is one of the first times that an entire population of petitions in a single county has found this to be true. And so we became very interested to note this because it is a category that may involve potentially some discretion and may encompass maybe a net that is cast wide enough for girls that allows girls' gender nonconforming or survival behaviors to potentially be labeled as simple assaults, resulting in a juvenile delinquency allegation.
Can you just, as I move to the next slide, define your state your definition of simple assault for purposes of this research?
How we define simple assault for purposes of this research. It was really defined based off of the category, based off of what we saw, the actual charge and the codes of the charge that were included in the petition. So it is what was defined by law as simple assault. Okay, now we wanted to know that we wanted to look into the population of youth who were sent to residential treatment establishments. And here we just simply see what that population of youth looks like. So 74% of all youth in residential treatment are girls and 26% are boys. So already we have more youth in these facilities that are girls than boys. And what we found, that we found striking and quite disturbing was once a child was in a facility, girls had a 1 in 2 chance of getting a new juvenile delinquency petition filed, compared to boys who had a 1 in 8 chance of getting a juvenile delinquency petition filed. And this is for all youth who are residing in residential treatment facilities when the juvenile delinquency petition was filed. And as you can see, there were more girls, but even proportionally speaking, what these data suggested was that if you were a girl who was sent to a residential treatment facility, it was essentially the flip of a coin, a 50-50 chance, whether you would come out of that residential treatment facility with a juvenile delinquency offense alleged against you, even if you did not go in to that residential treatment facility with a juvenile delinquency history. In other words, even if you just had a PINS history, let's say, that brought you to that residential treatment facility. This was not the case for boys. Although, as I will show you in a minute, boys entering residential treatment facilities had more serious prior histories of delinquency, had a more serious offense profile going into the residential treatment establishments than did girls. And if you can go back for just 1 second, Kristen. Thank you so much. I just wanted to mention this section on community. So what you see is when you're in the community, when a juvenile delinquency offense is being, a petition is being filed outside of a facility or in the community, boys are receiving those 78% of the time, whereas girls are receiving those a quarter of the time. When you look at the juvenile delinquency petitions that are resulting in facilities, the pattern flips completely, and it's girls' behavior that's being labeled as delinquent much more frequently than that of boys here. I'm sure folks might want to know, a part of our kind of deeper dive into these data that has allowed us to really code the nature of what is written in the text of the allegations, to really qualitatively code the allegations, suggests to us that for girls receiving juvenile delinquency petitions in facility, staff at those facilities are by and large the most likely petitioners. And so it becomes even more a characteristic of the system's response. It implicates, in my opinion, the response of the system even more strongly, because the pathway so far suggests that girls who have a who have less serious offense history going into residential treatment facilities are more likely to receive a new delinquency offense, and to do so at the request of staff who are the petitioners of those delinquency offenses. What are these delinquency offenses for? This chart shows that to us, and it demonstrates that for girls, by and large, it is for simple assaults, where of all of the simple assault delinquency petitions that are filed for youth in residential treatment, about 91% of them are for girls. Girls are also represented in the minor offense and other categories. I would argue these are a little bit more potentially discretionary as well. Other includes a range of different things in it that are not necessarily systematically coded. But you can see that boys, when they receive delinquency petitions, which they do at 4 times less often than girls, they receive those JDs for attempted assault, sexual offenses, criminal mischief, and robbery, whereas girls receive them for simple assault, minor, and other offenses.
And if I could just pause there for one moment, just for maybe anecdotal context. When you say these simple assaults in these residential facilities, were you able to ascertain whether or not these were essentially fights among the residents or fights of the residents with staff? Can you just elaborate on that just a little bit?
Sure, I would be happy to. So yes, these simple assaults constituted a few different kind of qualitative categories as we coded them. Some of these were fights between the girls themselves. So maybe a group of 4 or 5 girls would fight with one another, and all of them would receive a simple assault charge. Some of them, it seemed more to constitute threats against the staff as they were written in the petition. That could be interpreted as, threatening or the potential to include violence. Some of them sounded like harassment related, incidents that again involved sort of threats or talking to staff members in ways that staff members suggested were violating the rules of the facility, but that did not necessarily read as illegal in the community necessarily. And others included physical interactions with the staff.
And I think just to put a penal law fine point on it for those who are asking in the questions, the majority of the time for the petitions you looked at, I believe, based on our conversations, when you say simple assault, you mean misdemeanor assault.
Yes.
Right. Thank you.
Absolutely. Yes, that's right. And here that is. So of all of the different types of offenses, cut a different way, for girls, you see them overrepresented in misdemeanor and nonviolent felony, whereas boys' juvenile delinquencies were either counting as technical violations or as violent felonies, categorized as those kinds of charges. And so yes, the simple assaults were really misdemeanor level simple assaults for girls. Wonderful. So what we wanted to also do was to take a look at the PINs, or the persons in need of supervision petitions, to understand, do petitioners file different types and severities of charges for girls versus boys? Do petitioners use different language to justify allegations for boys versus girls? And how do we understand those petitioners' justification based on the severity of charges, and based on how many kind of charges that they are checking off in that petition paperwork? Does that differ for boys versus girls? We wanted to get a little bit of a sense of that potentially that first part of the pathway where you can imagine that girls are coming in initially to court on a PINS petition for engaging in behaviors essentially that could be considered illegal if you are under the age of 18, but not necessarily so for adults. So including things like truancy, running away, incorrigibility is a box on these petitions. And so we wanted to take a look at what we could glean around why girls are receiving PINS petitions versus boys. Great. And so here's a breakdown of the different types of allegations by gender. And you can see here that all the way on the right side of the screen, girls are overrepresented in the runaway category. They're also represented in all the way on the left side of the screen in the truancy and incorrigibility category. But that they are similarly represented more or less in some of the other categories, except for when you combine, for instance, truancy and incorrigibility, girls are slightly more represented. And this just gives us a little bit of a breakdown of whether there are gender differences in the boxes that a petitioner is checking when they file an initial PINS petition. And we see that, yes, indeed, the allegations do differ by gender, and they mirror some of the national data that suggests that running away is a category in which girls are overrepresented, but also truancy, which really highlights the school to prison kind of pathway, as well as arguably one of the broadest and most subjectively defined categories, incorrigibility, is also overrepresented by girls for the PINS petitions compared to boys. And so here are some of the findings with respect to these petitions. So first, PINS petitions concerning girls, which constituted 63% of overall petitions, highly outnumbered those concerning boys in the sample. Girls just were more likely to have a PINS petition by almost twice as much compared to boys. But when examining proportions of PINS petitions within the fuller sample, these gender disparities emerge. And as you saw in the previous slide, we can really focus on running away and truancy as the places where girls are being overrepresented compared to boys.
I have a question coming in that I think it would be timely to ask you now rather than wait, and that's to talk a little bit more about incorrigibility, what that traditionally means, and what the implications are for these types of petitions.
Sure. Thanks so much. That's such a great question. Yeah, incorrigibility has a very troubling historical roots. I would definitely refer you to check out the Incorrigibility Project, which is led by Allison Curran, who has documented sort of the history of incorrigibility in New York State in particular. But what I can say now, and what I believe that project supports, as well as some other research in this area supports, is that incorrigibility is a term that has traditionally been used to capture when girls are engaging in gender non-conforming ways, or when they are engaging in ways that are seen as unladylike or troubling. And so historically, much of the incorrigibility offenses alleged against girls occurred when girls were being sexually abused by adults, but that the girls were charged with being incorrigible and sent to kind of training schools in order to correct their incorrigibility. And so this is why I say there's a troubled past, and it's important to look at what the current implementation of this category has been, since it remains an option on the PINS petitions for a petitioner to check. Okay, great. And here we have justification categories that petitioners use. These were coded based off of the text that petitioners wrote in the open-ended parts of the actual petition. And we categorize them based on roughly 7 different categories. And those included sort of, are you bringing are you making this petition because you're worried about the safety of the child? Was it because the child was stealing? Was it because of an absence? In other words, the child was not where they were supposed to be, whether that is home or school or a different place that you asked them to be, but they were not there. Is it related to substance use? Is it related to mental health? Is it because you're worried about the child physically harming someone else? Is it that you're worried about the child engaging in general hostility against others or themselves? These codes they existed for both boys and girls, but in sort of through a different spread. So as you can see here, absences are by and large the main reason that petitioners are citing when they fill out a PINS petition for both boys and girls. The kids are not where they are supposed to be. I'm filing this petition for that reason. Barring absences, safety is the next most important reason why girls are having a PINS petition filed. And that is, again, I emphasize safety. There are the concerns about a safety to the girls themselves. So if this petition is not filed, I worry about the safety of this child. If something else doesn't happen, I worry that this child will not be safe. That is happening for boys as well, but it's happening almost twice as frequently for girls. Whereas stealing, substance use, physical harm, and hostility concerns are represented far more frequently for boys than they are for girls. And that is the girl-boy comparison there that you see circled, safety versus physical harm and hostility. We can see this cut up in a little bit of a different way as well. So for charges, for petitions that had more than one box checked, for the petitioner saying that there's more than one reason that I'm formally filing this petition, we can see that hostility and physical harm were the articulated reasons of the petitioner for boys, much more so than for girls. So petitioners were worried about boys engaging in physical harm against others 80% of the time, whereas it was 20% of the time for girls. And similarly, petitioners were worried about boys' engagement in hostile types of behaviors that may not have included physical harm, 73% of the time compared to about 27% for girls. And so some of our takeaways here are that of all types of these PINS allegations, there were more runaways for girls than for boys, that parents who were filing these petitions in the community, in particular, were more likely to justify the PINS allegation using language about safety for their daughters, which was mentioned in approximately 40% of girls' PINS petitions, compared to being mentioned in about a quarter of boys' PINS petitions, and that hostility, stealing, and physical harm were significantly more likely to justify the PINS more serious multiple charges for girls than for girls' petitions upon filing.
Okay, for anyone seeking CLE credit, I'm going to interrupt Dr. Javdani for a moment and give you your first code of the presentation. It is cello, C-E-L-L-O, the musical instrument. I'll leave this slide up for a moment while I ask a few questions that came in before we get to Dr. Javdani's wrap-up slides. One question that has come in a couple of times is, what are the clinical or developmental factors impacting the differences between boys and girls benefiting from individual and group programs?
Mm-hmm. It's a great question. I think that one of the things that we found as a result of that study that found that group formats were particularly not beneficial for girls is that many of these group programs had an accountability piece associated with them to some degree, some to a much larger degree, like let's say, for instance, like an anger management type of program, and others to a much smaller degree. Let's say it was an arts-based group, but that there were some accountability related factors associated with it. I think that when we think about the population of girls, girls of color, 40% of whom identify as LGBTQIA, who are being referred to these groups, and we know that many of them are reporting sexual abuse histories and trauma histories. We know from this and other research that engaging in behaviors that are captured under incorrigibility, or not being where they're supposed to be, or running away from home, can constitute survival behaviors that are a response to the community and home traumas that they might be experiencing. And so with that backdrop of the intersecting identities of girls, and also the understanding that girls may be running away from abusive situations, may not be going to school because of fear for their own safety, which is corroborated by 40% of petitioners even saying, I'm putting up this allegation because I'm worried for her safety, right? When you combine all of those factors and then you invite that girl to a group with other girls who are coming in with similar histories, but their own lived versions of them, of course, and then you bring accountability into the picture, that is the recipe for a therapeutic environment that is not validating, right? If we have not understood the context that has brought a girl there, then, and asking her to think about what she's done or to control her anger, that to me is a confluence of factors that would possibly make me more angry if I were a participant of that group. And some data, some very small studies have actually shown that one of the correlates of anger management groups for girls and women is that they leave angrier, or that they leave and just don't come back. And so I don't think that that answers your question about sort of the clinical or the developmental implications, because I think that the boys and girls in this population of this age group overall, this average age group, about 13 or 14, overall can be engaged with a multitude of different kinds of clinical formats. But I think that the experience of being a trauma survivor and for engaging in behaviors that are then deemed delinquent because you're trying to survive that trauma, but then being asked to be accountable to your own emotions, is potentially a really invalidating experience that can cascade, so that over thousands and thousands and thousands of youth, we find that those programs are not only not effective, but they can actually be associated with worse outcomes for girls, but not for boys.
Well, I gave you a harder question, so as I move to your concluding slides, I'll give you an easier one. Someone is asking for a definition of PINs, and I think we have taken for granted that perhaps everybody participating might know that. So for those who may not, if you could talk about that briefly as I move to your next slide.
Sure. In these data, PINs stand for persons in need of supervision, and essentially they encompass status offenses as opposed to delinquency offenses. And so these are the types of behaviors that might be considered illegal if you are a child, but not necessarily if you're an adult. So they include those categories that were up on that slide: running away, truancy, incorrigibility, right? Those are not categories that an adult is going to necessarily be arrested for, but they are offenses that, as a result of your status as a minor, could bring you into court, and PINs is the route by which they do so in this sample.
Thank you.
Sure. Okay, so just in conclusion, I just want to highlight, a couple of different aspects of these, of the pathways that we see here for girls with respect to PINs and juvenile delinquency petitions. First of all, we know that even though girls are more likely to receive a PINs petition or PINs allegation, a higher rate of these filings are for lower level offense allegations compared to boys. And so you can see that even when you look at if boys are coming in for sort of substance use concerns, or if boys are coming in for marijuana specifically, whereas girls are by and large coming in for incorrigibility, running away, and truancy. We see, as we have seen many times, that there are significantly more runaway petitions filed for girls. Running away is a classically sort of thought about pathway into the juvenile legal system for girls. Because of histories of sexual abuse. And I say histories, but really we mean currently occurring sexual abuse or sexual trauma for girls. And it is important to pay attention to that behavior and why we are criminalizing it potentially and what happens as a result of it, especially since safety is used to justify filings for girl status offenses by the petitioners, including parents. The vast majority of the petitioners for PINs here were parents for both boys and girls, but they're citing safety as a reason for filing the petitions for girls, as opposed to citing physical harm and hostility, more so for filing the allegations for boys. And as I mentioned earlier, information on race is systematically not collected in these data, although we know from national data that anywhere from 70 to 85% of petitions filed for youth at the national level, at the PINs level, are for girls of color. And so we know that those disparities, those racial equity challenges are clearly present here in the PINs pathway. So, and for JD petitions, as I mentioned, over half of girls' delinquency petitions are actually filed when they are in residential treatment establishments, suggesting that girls have a 1 in 2 chance of having a delinquency petition filed against them, oftentimes by staff of those facilities, oftentimes for a low level or misdemeanor offense, compared to boys who when the JDs are filed, even though they're filed less frequently, they're filed for much more serious offenses, and that a high rate of youth of color are charged with juvenile delinquency petitions. 97% of the JD petitions are for girls of color, 92% are for boys of color, just in this sample alone. And as I mentioned, we looked at the entire population of petitions. And so the overall pathway that I will just end with, what we are seeing here, what we are finding in these data, are that it is possible that a girl is brought into the system through a PINs petition because of a petitioner's worry about her safety, potentially for running away or for engaging in truancy or incorrigibility, whatever that means to the petitioner. It is possible that somewhere along that pathway, a residential treatment establishment is suggested as a place for girls to go. And upon entry into that establishment, there's a 1 in 2 chance that that child will come out with a new juvenile delinquency petition that will be for what does not look like as a minor offense, that will be for almost certainly a misdemeanor level simple assault, despite the fact that boys going into residential treatment establishments have a more serious offense history and also get JDs for more serious types of offenses. So I will end there and open up to Kristen in case there are questions, or we're moving on.
Yep, we have about 4 minutes to handle a handful of questions that I have not yet asked of you. One is fairly simple. Can you reiterate the text that you recommended about incorrigibility? And while you verbally do that, I might ask, perhaps Mackenzie can put in the chat box, type in the chat box that the relevant information.
Great. Yes, it's called the Incorrigibles Project, and it's led by Allison Corinne, and the website's great. Mackenzie will link it in the chat.
Thank you. This one, I'm not sure that you have an answer for, but being a researcher, perhaps you do. Is there any answer out there for why more girls run away than boys?
There's two evidenced answers in the literature. One is that girls are more likely to be running away from abusive homes. So girls are more likely to, for instance, be both sexually and physically abused by an adult person who has access to them in their home. The other response is that girls are more likely than boys to get a formal petition of running away for engaging in the same behavior as boys.
And does the research seem to suggest that the larger number for PINs, of PINs for girls, perhaps indicate parents are more protective of girls than boys?
That is absolutely a very important kind of theory that some evidence supports, including some of the data that we have looked at as part of this larger study. And when, you know, researchers have done experiments sort of in laboratory settings where they have primed participants about sort of a girl engaging in a status offense versus a boy engaging in a status offense, respondents do demonstrate more protective tendencies towards girls, and they demonstrate kind of a boys will be boys type of tendency in characterizing boys' behavior.
Great. I would just ask, I see Mackenzie posted the incorrigibles information in the Q&A. I'd ask if you could just put it in the chat as well so that everyone can see it. And there's more of a comment than a question that there seems to be limited existing options to address truancy other than the PINS process. Do you have any thoughts on that or suggestions?
One of the most effective ways to address the truancy to legal system link is to reduce the presence and role of school police within educational settings. And this is especially for girls of color. I would refer you to Monique Morris's book, Push Out, which actually was a book that every conference attendee received at the beginning of this partnership when we convened a conference, I think in like 2014 or 2015. And I know that's not the specific community level necessarily response, but it's about sort of understanding the reasons why truancy is happening for girls, which often has to do with not feeling safe at school. And so oftentimes the tools of school resource or school safety officers are to engage in some level of discipline for youth engaging in behavior that is not wanted. So truancy is an unwanted behavior. Don't want youth to be truant, right? And so we don't often get at the context of why that truancy is occurring, using the tools of law enforcement to sort of try to discipline around truancy.
And I'm glad you mentioned the work of Dr. Morris, because it was referenced in a particular question, which I believe that you answered to a degree. But the question that was posted was, is there a way to capture the information, the statistics that you started with, more specific to girls and boys of color, similar to Dr. Morris's work?
Mm-hmm. Yes. So in terms of the percentage experiencing mental health challenges, and yes, absolutely. That information is, I would say, I would refer you to a couple of sources that, Mackenzie, maybe you can link as well. Thank you, Mackenzie. One is a report by Georgetown Poverty and Law Center called Girlhood Interrupted. Which is a great report. It's not specifically on those statistics, but I think if you're interested in those statistics, this report will be really, really illuminating and interesting. And it's around girls of color in particular. The other one is Francine Sherman's work on gender justice. Which is, its full report is published and also includes some of those statistics and much more sort of compiled in one place. So those, I think, are some very specific, very important references. And then I believe that the report Sexual Abuse to Prison Pipeline also disaggregates for by race and ethnicity, looking specifically at that trauma pathway from sexual abuse to eventual potential incarceration for girls in particular, and also for girls of color.
Thank you. We need to move on to our second panel, but I have one quick thing. If you know off the top of your head, was there a difference in percentage of petitions, and I believe they're referring to PINS petitions, that were filed by parents versus community or non-parent petitions?
For boys versus girls?
Yeah.
Not really. Maybe a couple percentage points, but for both boys and girls, over 90% of the petitioners were parents.
Okay.
For both, for PINS.
Okay. And lastly, I don't believe your work encompassed this, but I'm going to ask anyway, whether parental neglect and abuse was investigated when a girl runs away, since that could potentially be the cause for the runaway.
Absolutely, it could. It is not systematically clear whether that was the case. Sometimes there was a reference to a history of child welfare involvement in the police reports, but we only had those for the juvenile delinquency offenses. And so we just did not know in the PINS petitions whether that history existed or not.
Wonderful. And I see Mackenzie has gotten all of those resources linked in the chat box. So thank you very much. And thank you, Dr. Javdani. We're going to turn now to the response to this information, this data, and we're going to turn to Judge Davidson and Judge Fisher. I want to note, I have a question here regarding the forms to fill out for purposes of CLE. I believe those links to those are found in the email that you received to participate in today's program. And if I am mistaken, I would just ask perhaps Marquita to put in the chat box where they can be found. As we do that, we'll move on to the response. And I will ask Judge Davidson first. We'll start with her. If you could tell us a little bit about your background and if there's anything in particular that led you to this work.
Thank you, Kristen. I want to thank the Gender to Promote Fairness in the Court and the chair for featuring this topic. I want to thank you that here in Westchester, we've been working on this for 4 or 5 years. And I also want to thank my stakeholders here in Westchester who courageously decided to take this on many, many years ago. And I think what you don't know about me, and I think that's important to understand why I believe this work is important, is that as an African-American woman, and I'm the first generation since my parents who grew up under segregation, and they probably didn't see desegregation until well into their 30s. And so the issue of race and color and the effect of color on our lives was a constant conversation. I come from a family of 4. I had 3 older brothers. 2 of my brothers were very brown. And every step of the way in our particular lives was surrounded about what would be the effect on our family from where we moved, from where we went to school, and myself my mother thinking about if we move to New Rochelle, we have a better opportunities because it's a diverse community and your brothers will be accepted, even down to if we move to this community, you may not have any play dates. And so that's the framework that I bring to this. In addition to having in middle school, which was junior high school, a simple assault or a girl fight under this particular and in this world, it would have been a 0 tolerance. Who knows what if I would have remained in school, and who knows what if I even be sitting here today. So I think, and also having been stopped in a grocery store with the only explanation of why I was stopped was either I was a light-skinned Black or a Latino. So I come to this from the perspective that I've lived this. And so what the data that you've just seen today is data stating that this is institutionalized racism. And probably maybe a couple of years ago, I wouldn't have told you a little bit of the background, but I think it's important that you understand my background and understand when women of color speak, they speak from their own truth, their own experiences. And that's what pushed us to do this work, because we knew that we were not getting the correct response. When I'm sitting in the court and looking and seeing mostly girls of color before me, I intuitively would know that that's incorrect. Fortunately, along comes with the data and the research, you now can confirm and show and know that this is what institutionalized racism looks like.
Thank you, Judge. And to your point, we just heard about that data, and how does that information resonate with what your lived experience was or has been in court leading up to your work, either anecdotally or systematically?
So prior to the data, you sort of like, which comes first, the chicken and or the egg? And I know with some of our counterparts, Dr. Tracy and Rashida and some of AFC, we would sit around after a case saying, what's happening to our girls and within the community, but not understanding how it all connected. And so the data really gave us validation. It really said, oh, they're not going again talking about race. The data gave us validation to say what we're seeing is in fact true. Because this is racism in 2020, and at that time, probably 2017. So without having the data, and it's, as we say, time and opportunity comes at the same time. And so in this day and age, we can present to you what institutionalized racism looks like, and also present to you some options, but it coincided. So the two of the things came together to support what women of color have known all their lives and have grown up with and understand to be.
Judge Fisher, I turn to you. If you could talk a little bit about your experience. You're geographically in a different location than Judge Davidson, in a different judicial district. Was there anything about your experience on the bench that resonated with some of the data that we heard about?
Not necessarily on the bench. Prior to coming to the bench, because I sit in Civil Supreme, one of the reasons I volunteered for this is based on my experience when I was practicing. My first job out of law school was at the public defender's office, and I was assigned strictly to family court. And I was there and representing individuals in neglect and abuse proceedings, women of domestic violence. And I also was on the AFC panel, and I saw a lot of what was going on in terms of, especially on the representing the girls in the JD and PINS proceedings, and being assigned to represent them on some of these issues like you're talking about, truancy, and being disturbed at the fact that charges were being brought sometimes against the children as opposed to the parents when there was issues going on. For example, I can clearly remember a specific case where the reason the girl wasn't going to school is because her stepfather was sexually abusing her, and she had trust issues with men, and all of the teachers and her guidance counselor that were provided for her in the educational system were men, and she was terrified of men, rightfully so, but no one had spent the time to talk to her to find out what was going on and why she wasn't going to school. It was easier just to file the petition. And the same thing sometimes in the neglect proceedings, and I was wondering if anyone else was going to touch on that. Sometimes there's issues where you see parents or, have DSS involvement in their life, and they're afraid that they're going to have a neglect petition filed against them. And it's easier to go file a PINS against your rebellious teenage daughter and worry about the younger children being taken away, or worrying about having the boyfriend removed from the house or orders of protection stay away, and how the whole family is going to be disrupted because of this girl, and how the blame always gets turned over to the girl. The girl is the victim, yet she turns out to be the one that's charged, the one that's the problem. And that's really why I wanted to get involved with this.
Thank you, Judge. Judge Davidson, I'll turn it back over to you. As Judge Fisher brought up PINS, I happen to know a little bit about your background, and I know that you spent a lot of work and time doing PINS. Did you have any thoughts that you wanted to add to Judge Fisher's comments?
Oh, sure. So, I too was an attorney for child in the Bronx, also here in Westchester and 9th JD. So clearly the PINS petitions are the most troubling petitions. And I also have to say, going back to that word incorrigible, how that also really affects girls of color, because many of the studies show that girls of color are seen as more aggressive, more mature, more over-sexualized. So that's a blanket word for us. And we notice with the PINS petitions, and even as as Dr. Shabnat said, in the petitions, it didn't show that the outside work that was done with the neglect petitions, but we could see that from the file. So many times, the PINS petition were really the crossover youth. And so you'd have a young person who came up because the subject of, the mother was the subject of an Article 10. And then as time goes out, that trauma, because of the abuse that they were subjected to, you get to a point of 13, many of these girls are beautiful, they run, they get involved with older men. So it is exactly what Dr. Shabnat said, it's running away from something. And I would say, and this is anecdotally, the majority of the cases that I saw, whether it was in the Bronx or whether it was in Westchester County, that the basis initially was in Article 10. And we would try to do many things, even with the PINS petition and bringing in, because our stakeholders included the Department of Social Services, probation, and begin to try to work with the family. But most of the time, I would say almost all of the young people we had, there was some Article 10, and for those of you who are not from the family court world, they would be the neglect petitions, neglect or abuse. And at that point, when they hit that 13, 12 age, things just exploded. And that's where you see the quote acting out.
Great. So turning back to grip court in particular, Judge, if you could talk, I know a lot of training went into this, and we could probably spend a whole hour just talking about all of the training and peer learning that you and your team did. And actually, before we get to that, can you talk about the composition of your core team, your executive team?
Sure, thank you. So our core team consisted of the Department of Social Services, John Beefus. We had Rashida Cartwright from the Presentment Agency. We had a petitioner, a pediatrician was Dr. Tracy Gardner. We had attorneys for children. We had Jasmine Hernandez, Robin Carton, my own staff, including Margarita Garcia, Nicole Shipsaran. And beyond that, we would also have all of our youth bureaus. I must say Westchester County embraced this in such a huge way that we would have a ninth floor conference room and have almost a good, 15 to 20 people sitting around that room. And so if any of them are on today and I forget, I'm sorry. But we have our local youth bureaus who were part of this. We had the YWCA, because many of you know, one of their missions is to address racism, and specifically for women. So our core group was a group where we really started to talk about, and when Dr. Sharma came in and said, we need to look at your petitions, the sweat started breaking down. Oh my gosh, what do you see? But we knew that unless we were open and honest about what was happening in our community, how were we going to help that? So that really, and as I go along and I look at my 20 million pieces of paper, I'll talk about all those else, everyone else was part of it. But that core group really dug deep to create the girls' court, which is now called the grip court. And so all of us at some form went to some of these trainings that you see that are listed on the slide. And I have to say this, that this was a labor of love. This was not an easy project. Not everyone was a firm believer. We had, who's now a judge, Judge Wayne Humphrey, he was very angry about the fact that we wanted to do a project for girls. And, by the end of the day, at the end of 3 or 4 years later, and now we're including boys, but this was not easy. Not everyone saw the wisdom of having a girls' court, a girls' initiative, focusing on her. Even some of my initial legislators that I went to seeking for support.
So turning to the training piece, were there any particular ones that stood out to you, and why? Can you tell us why the training was important for this project? All of them are great. I think the Georgetown, I'll highlight really 3 of them. The Georgetown project, which the focus was on LGBTQA youth, and Westchester ended up getting we became one of the fellows for that. We really dug deep into the issues facing the youth. And we really wanted to make sure that was part of the girls' court. And that was difficult in us because it was a 3 or 4 days training, and a problem for us initially, the issue of race after 2 days never came up. And so this is the issue, and I hope I say her name right, but she is the head of Women to Women. Her name is Zainab, I would pronounce it. But she said, if you turn away from discrimination, then you legitimize it. And so the training really helped us to see how we had to really take in their voice in a very meaningful and strong way. I think the Rosebuds is another great program for us, because the Rosebuds are youth that have been either in the juvenile justice system or the Article 10 world, and they actually form peer-to-peer for the girls right in court. So when I get a girl that would come into court, right then and there, we would sign a Rosebud who's there for them, for their support, that one-on-one. I also think the training that actually was the ACES training was very powerful. I have the exact title of it here. That was very powerful because I think many of us who do this work
if we take the ACEs test, begin to look at our own trauma. And Dr. Tracy Gardner was a huge proponent of looking at the trauma, not only our lives, but the effect on our bodies. And I think our trip to Los Angeles, and Dr. Shabnat, you were there, that was very, very, very powerful. So each one of them really touched on a different aspect. And the Young Women's Freedom Center actually did some training for us via Skype at that time. And we also visited just a little bit, and it's a lot because a lot happened, but of all the girls' courts across the United States, we had actual conversations, I think, with each one of those courts to determine what worked or didn't work. So the foundation for this has taken a lot in terms of first looking at what's out there, then what can we take? And lastly, the most powerful one for me was, not the most powerful, but moving for me, as the one regarding sex trafficking. And that really traced the life of a young girl ending up being trafficked. So those are some of the things, and it sounds like a hodgepodge, but it was a lot, but it was transformative.
Great. Now I have the mission statement up, and I have it up as a backdrop. If you would like to comment on it now, or we can come back to it. But if you could just kind of give us an idea of what GRIP Court is.
So GRIP Court, which initially started off as Girls Court, is a court, and GRIP stands for Gender Responsive Initiative and Partnerships. And it's really the goal, exactly what it says, to really promote healing and justice and supportive interventions. Our belief that a huge part of the answer is in the community. So it's really to look at the young girl sitting before us in court. How did she get here? So her path, her story to getting before court is just as important as the ultimate resolution. Clearly, it's a dispositional court, but what it provided for us was an opportunity to really put in these resources that we found that girls needed to have. What happened for us and how we transformed from the girl court to the GRIP court, and as I say, maybe Judge Humphrey was whispering in our ear, there was two young people who came in, it was a boy and a girl. And so we had to make the decision whether do we bring just the girl into the court and allow the boy to go off into the traditional JD world, or bring him in also. And so the decision was, and we already had the research and we already had the benefit that the type of work that we would do for girls would, and again, benefit a boy. So that's how we decided that we should take each case by case, as you'll see from the form of the GRIP Court brochure. A lot of the decision is being made by the presentment agency, by Rashida Cartwright, but we decided that we would include boys in that.
What is it that you were looking for the GRIP Court to actually represent to the attorneys, to the community, to the girls themselves?
So I think the first part of the GRIP Court has to be the acknowledgement that there is institutionalized racism in the court system. Not that anyone calls it, but I think, as I was saying before, that's the first part. And because that there's institutionalized racism, not that someone made it happen, but this is how that's that case, that's that young person before you. We must then have a response that is culturally competent, addresses the issue, and understands that probably, like myself, that person was probably stopped somewhere for doing something that in no way they were. So the goal of it is first to have the acknowledgement. And I think that's what the first part, because you're not going to be able to do this work unless you internally understand. Doesn't mean that you have to be Kathy Davidson, or you have to run around and have a police stop you, or you have to get in a girl fight. But understand that these experiences have led to the trauma, the poverty, led to that young person there, and then respond in a way. A judge has great power that once that young person, you have a way, especially in family court, allowing that young person, whatever brings them before the court, to leave without any type of record or sealed record. So the judge has the power to change this person's life. And I can't tell you through letters, through pictures, how a young person will say to me specifically, I finally got that someone believed in me, because many of these young girls don't have anyone believing. So this is a great opportunity from whatever cross-section of the world you come to. acknowledging that will better inform the choices that you'll have when you will address the issues that brought this young person before the court.
Great. So that brings us to, you know, eligibility, or how would a young person kind of end up in your court or have this court made available to them?
Well, the way it's done in Westchester, you know, a couple ways. The initial way in the brochure is generally the presentment agency will look at cases and have the ability to kind of look and see that, you know, we're taking not so much low-hanging fruit, we're taking the more difficult cases. And because that's what we also saw, that the girls were coming in with the more serious in terms of what maybe I saw when I took the bench in 2004. But now what we will have, because of it's out there, you may have another judge saying, I think this is appropriate for a girls' court. We have now attorneys for children suggesting that it would be best for that particular case to come into girls' court. So now, you know, the initial way and in our brochure, but now it can come from any particular direction. And I also want to mention, and I don't want to forget this, and I think it's very important that some of the things that we're bringing to this court, which is really made in terms of mentorship, is bringing in the Black fraternities and sororities. They have become major supporters of this. And most of the Black fraternity sororities, their mission is to help young people. Many of them are connected to historically Black colleges like myself, Howard Law School. And so they have embraced this in ways that were almost holding them back. But the concept for us is to give these young people, and not just the African-American sororities and fraternities, we also have a Latina sororities who's assisting us. Thank you very much, Jasmine Hernandez. So that's the kind of concept. We want to expand beyond the court because we're just judges. And so I can't be a counselor, I can't be their best friend, but I can make those connections. And the answer for, especially for communities of color, are generally in the community. So that's how they get to us. We already are being asked to have a court in Mount Vernon, and that's by the way of the school from Brother Arthur Muhammad, our superintendent from Yonkers. He has requested we start a grip court there. So it's now understanding and again seeing the data and understanding that this institutionalized racism can best be addressed. Because if we understand that that was the whole purpose of Brown v. Board of Education, was to address the way that education in such a way, and it was a success. And the same concept, the same privilege that I received, there's a book called Children of the Dream, which talks about the first generation of people, which is myself, who benefited from Dr. Martin Luther King's dream. So I am a child of the Children of the Dream, and it was a success. So in these demonstrations, this model is a success and can make the change.
And I noticed though, as far as the points that are up on the screen, that you know, there seems to be some hard and fast rules, but they have an asterisk behind them. Can you just explain whether or not those are hard and fast rules actually, or if exceptions can be made?
Exceptions are made. You know, sometimes, you know, I am a self-proclaimed liberal, and when I first came in to do this work, I never thought that I would ever be able to remand or place a child in a group home. Sometimes the situations in the home life are so horrific that it's just not the safest place. And it's hard for me to say that, but we do have group homes and facilities that do work. So we do work with some of the girls. They will go home, it may not work, but we still work with them through the group homes and the residential treatment facilities. So we say it, but no, it's an exception. So not. The only thing that's probably hard fast is probably the designated felony, the arson and sex offense.
Mm-hmm.
Those
Could
pretty
you
much.
Perhaps, and I recognize I'm putting you a little bit on the spot here, but could you perhaps give us an example of a case, obviously, you know, protecting all identity, but can you give us an example of a case that you thought perhaps, you know, maybe wouldn't have traditionally been a part of a court like this, but that you accepted, and how that panned out?
Well, I guess there would be the cases that traditionally, yes. So the case really would come in before the court. A lot of, like we said before, the cases come in from the perspective of something happens in school. And that is true, as the data shows. The fight in school, coming to school, and then the mother comes in, I can't handle her. And so in that particular case, it came into the court, and we realized once after an admission was made that the recommendation was for her to go to a facility really addressing her drug issue, which is really marijuana. We kept the case. We kept that case because, as they say, it became important to us that she needed every single support from the Rosebud. We have a lovely young lady who was in the system herself, who's come back to help with the girls. She needed all those supports because her mother just was not able to care for her. Just the mental illness was on such a level. And I know all of you that do this work, when she came out of the residential facility, went back home, again, she had to start taking care of the mother. And so she was not going to be able to be who she needed to be at home. So finding a group home in that instance, and this young lady that I had in the beginning of my judicial career was able to really walk her through and show how she was able through, although being not in love with the group home, it provided her a way to get an education, to go on to be an airline, so all these things. So traditionally, we probably wouldn't have taken that cases, but what we're finding, and especially as Dr. Shabnat said, those cases where the young person came into the residential facility either because of offense or because placed on neglect, because they weren't able to remain at home. When that JD was filed, came into court, and we decided to keep them in the court. And also the boys. The boys are a big concern. And usually, a couple cases, the schools are so concerned about the boys, and especially with the gang involvement, they'll begin to say that, please take this case.
That's great, thank you. I want to move on to, you've touched on some of the features, but what is it that makes the case in your court, in the GRIP court, different? Who are the players? Who are the folks sitting around the table and participating in these matters?
So I want to say too, I'm sure that there are a lot of judges that are doing some form of this work in some way. So I don't want to act like I'm the be all end all. But there's typically a conference, and during that conference, you'll see, as you have here, you have the initial conference without me, it's Attorney for Child, the presentment agency. We have a resource coordinator because the school piece is huge. Our court officers play a major role. It's interesting how we have a court officer whose parents took in foster children. So when a lot of the girls would get really upset, and they would end up having to go to secure when we won't say the reasons for it, it was that court officer would go back and say, listen, you really need to trust this judge. We're going to work with you. Wait the time out. So we shouldn't sleep on court officers. We also had a major support from our mediation, our cluster. And what we found, especially while mediation is very effective with girls, it provides that one-on-one. And I think, Dr. Shabnat, you talked about this at one of our many, many meetings, how girls have to talk it out. And I hope you'll talk a little bit about that. But the mediation, and Vicki Kanzam is actually at that meeting talking about setting up the meetings with the mother, or trying to, and especially in this, because if you think about it, the girls, and I even know my own girl fight, I mean, after you have these fights at school, they all got to go back to school again. So there has to be, and this is an area where we have to work with the schools, with the beginning to see some form of how to resolve these issues. So the roundtable conferencing happens the week before the court date to see what's happening, and probation is part of it. I want to thank Mary Facello, and so that happens a whole week before. We have DSS, who's Zuleika usually comes in, and it's every Wednesday, and it's the Wednesday before the actual court date.
I'd like to highlight a few things you mentioned, Judge, if I may. One is the scheduling. It seems you have purposefully put it on a consistent day and time each week. And I happen to know, and if you could talk about it, that all of the, for the most part, most of the stakeholders, most of the involved parties with this girl are consistent, and they are the same folks, that the same faces that they see in and out each week. Can you talk about that a little bit, and perhaps why it's important?
Absolutely. I think first because all of us have been through the journey together. So that's the first part. And the deeper we went into the work, and as in the word of Dr. Chapman, the deeper the dive, the more we became committed to the work. So it's not as if we have a AFC who's here for a year or two and they're off. They're there. And so it's the consistent group, you know, of Margarita, Robin, Jasmine. We have included, additionally, we have a few AFC males because of that. And actually that's been very successful too. It's been very, very successful. I think the partnership with the males have been extremely important. And so that's something, that piece of sort of dissecting what's happening in, if they're in residential treatment, what's happening there that allows them to come home. And then the community connection, because our goal is, if they are in the group or what do we need to do? And so it's every single Wednesday, every single day of the week, and all the cases have gone through completely what's happening from this day to this day to this day. And if we have to recalendar, we recalendar.
And in terms of consistency, just because you mentioned it earlier and how integral they've been, does that include even the court officers that are assigned to that part?
Absolutely. Absolutely. They asked to be part of it. They asked to be, and they're very effective with the girls. Because the biggest issue, and I'm, as I say, is the trust. So the girls need to see that consistency. They're going to see the judge, they're going to see the same court officers. That court officer, how are you doing from one day to another? You can actually see the de-escalation, you know, and also the concerns girls have, and especially without any political, under this administration, some of the girls having concerns, acting out because a parent might be deported and wanting to go to the hearing, and having the kind of relationship with a secure facility, a non-secure facility, say, Judge Davidson, if you tell me that you want to be able to have, so this young person can be at that hearing for their parent, we'll take them down there. That's the kind of relationships we have. Because I know I'll lose that young person if she doesn't get to see her father be part of that hearing and why she should stay. So that's the consistency that, you know, this big circle that's being surrounded for the girls in order for their support and their protection.
Can you talk to, which you just alluded to it, you essentially are saying, if I'm hearing you correctly, that you heard the voice of that girl saying that this is what she needed to continue to stay engaged. Can you give us some other examples, or, you know, anecdotally, obviously protecting identities of an instance, or kind of maybe when the light went on for you about a girl being heard and what that meant to her?
I have one that's an interesting one. It's over, and this particular, and in each way it comes a different way. It can come by way of letter, a picture, but she consistently represented that her mother just wasn't telling the truth about her situation, and the mother appeared very credible, the mother, and so, and she, when she would go back and walk out with the court officer, she says, my mother is just not telling the truth. I'm telling you, she's not what she says she is. She's leaving us. So one day the mother comes in and she missed court, and I said, you know, I need to understand why you weren't here. Your daughter's here, why you weren't here. She says, she brings me this note from the doctor who she works for. And so, you know, my father was a doctor. So I pick up the, you know, I'm a lawyer, I can't spell. I pick up and I look at the note. And in my head, I was like, there is absolutely no way a doctor wrote this note. It was impossible. And I looked at it, and at that moment, and her lawyer had male, Maurice Williams, advocating for her tremendously. I looked at it and I said, her mother's not telling the truth. So, you know, I had Margarita go call up the doctor. The doctor said it, and at that moment clicked for her, because at that moment she realized I heard her, that what she had been telling me, that her mother's not telling the truth, that I didn't do these things, I did. And so I heard her voice, and from that perspective, and even, you know, from the letters. So it comes in a different form, the message or the answer or the voice comes, it comes in a different way. but she was consistent, and her attorney for the child was consistent. Her mother's not telling the truth. Mother's not telling the truth. And sitting there as a judge, what do you look for to give her that verification? And there's one particular, I'm hoping at some point she'll allow me to share these letters, because I think the letters from another young person really talks about what internally she was feeling, and knowing, and this is the biggest part for the girls, that the court will not give up on it. Because many of them, the runaway, they would reach out to their attorney and say, okay, I ran away, they've taken out a warrant. My thing was to say to them, just come back and we'll start all over again, over again, which what we would do with anyone. So the voices come in different way, but the biggest thing for them to know is that not only myself, but everyone sitting around that round table, knowing we hear you, and we're going to respond.
Thank you so much, Judge. I'm going to give you a bit of a breather for a moment and turn to Judge Fisher and put her on the spot a little bit to get her reaction to some of these things that we've been talking about, and wonder out loud, is this something that you can see being incorporated into other courts or other aspects of court?
Yes, one of the things I was thinking is it's a shame that we don't have programs to help at the diversion level so that they don't get to the point where they get to the court. I think one of the issues is a lot of these girls obviously have trust issues. Someone has failed them along the way in terms of their development. Either they don't have confidence in a mother, they don't have confidence in anyone else to disclose what's happening to them, which is why they're acting out, and you see that behavior. It's almost like, and so they have issues with trust. And so, which I think would make it hard for, like in Judge Davidson's court, she has to reestablish this trust with her and her team for these girls to get them to participate. Because if you think about it, the people, usually it's the people closest to them, they're running away from home. And if you think about it, that's your family. Your family's always supposed to be there and have your back. So I think there's that whole component, if there's a way to capture them before they get there, in terms of, like we found out from what Dr. Javadi said, that the group counseling doesn't necessarily work. It's really more on an individual basis, because it seems like when they're in a group setting, it's not effective. But if we can have some type of individual counseling for the girls, I was wondering if there was any programs there that, or we should be looking at putting in programs in place that would help these girls with that, like I said, before they get to the level where they're going to have a record, or before they're appearing before a judge. I think sometimes, a lot of this too is, I don't know how to say it as eloquently as I wish to, is that there's a trust issue. There's also, the demographics of where Judge Davidson is compared to where we are once you leave the New York City area too. It's a little different in terms of the race issue also. And I think sometimes the race issue plays the opposite way, and they get left out of services, and they don't get services sometimes. I mean, I have to tell you, I was really shocked sometimes to see, and I think that goes back to the trust issue. There's issues with authority, people of authority, whether it's a police agency, a school principal, a probation officer, diversion, whatever it may be. So I think those are one of the things I think that's a big issue in terms of getting some type of counseling involved, or some type of group support for these girls before it gets to the point where they're in the system, or someone's filing a petition against them, or some safe haven for them. I don't know if anybody has any experience with that, if there's any groups out there, if that's something that's been effective.
Well, it's interesting that you bring up services, because that's the next piece that we're going to talk about as it relates to grip court. And before we kind of get to that, Judge Davidson, I just wanted to clear up a few things regarding grip court. It is a court of disposition, correct?
Correct.
Meaning?
So it's a court of disposition, which means that after there's either been a fact finding or admission, at the dispositional phase is where we begin to implement most of these almost all of these services that we've been talking about. So it's more of a case conferencing, meeting with it, but it happens after the fact finding or admission phase. And
So,
hopefully, I'm sorry.
I'm sorry, but one of the questions that has come in that I didn't want to wait until the end has to do with, at the end of their participation in GRIP, is the case dismissed? So if you could just talk a little bit about the outcomes.
Sure. So most of the time, if not, that is the ultimate end, adjournment and contemplation of dismissal, dismiss it. My goal is to try is whenever possible to ensure that these young people do not leave the court system with a record. Kids are very smart. Rashida was doing a mission the other day and she was going through the different levels, and when she stopped and talked about the ACD, if anything he knew, he said, I think that's the one I want. So the goal really for us being a dispositional court is at the end of the time frame, whether it's 6 months or a year, is to be able to dismiss the matter. So the young person leaves the juvenile justice system without any form of a finding. I think it's also important, and we've had many discussions about this, because our concern and why I'm very excited about the fact that the school systems have reached out to have a GRIP court is that many of these young people, because a lot of these actions happen in school, are already being punished. They're already out of school for an extended period of time. And that's why the importance of one, I'm not sure where you live, Judge, but when you have the sororities, which is a national and international organization, great many of the women that are in these sororities are school teachers, principals. So they're very good at addressing the issue of school. But for us, that's where the key becomes. So it is a dispositional court, and the goal was really that every child leaves without any type of finding at the end of the day.
One thing I wanted to highlight also, Judge, is something that I'm privy to, having worked with you on this work, is that the services that are listed and that we've been talking about, I think it's important to point out that many of them already existed.
Exactly.
That it was a way to just get everybody to collaborate and work together with a shared goal.
Exactly.
But it did not take any new, there was funding involved with the project, but the services themselves, most of what was accomplished did not require funding.
Exactly. For instance, when I spoke to each department that's represented here, it was really taking the work they're doing and changing the lens. So that's why I say, once you realize that this is institutionalized racism that's affecting girls of color, then what you're going to put in is going to be with that color of the lens. So it's really us sitting around the table saying, being directed by the data, what do we have that we believe will work? Me knowing, being African-American, knowing about the goal of the sorority leaders, that this could be a major resource. Taking Cluster, who did a lot of work in terms of the custody world, coming in and doing mediation, and Cluster goes, if they're in secure facility, they'll go there. If they're in non-secure, the home, they do all of the above. So as you say, you can create this court depending upon, where you are and what you have, just to begin to address it. And also the issue of race. Everyone that's working in this court, even though surely us as women of color know it in a different way, because they're not a huge amount of Black people someplace, it doesn't mean that the work can't be done. And so there's many ways to connect a young girl of color to another person of color who can be an example. So it's just sitting at the table and sort of talking this through, so everyone becomes the same mindset. So exactly what you're saying, Kristen. You probably have quite a bit of the things that you need. It's just putting it together so you have the right combination.
Right. And one thing I'm getting many inquiries about the second code, and it is coming up. But before we get to that, one thing I would like to highlight, and if you had any additional comment, Judge Davidson, please chime in, is the presence of the cross systems unit from the Department of Social Services. Now, in a traditionally managed juvenile delinquency matter, those folks would not be in the courtroom, correct?
Correct. In our cases, and especially as we're saying, because so many of the cases that we're seeing are really young girls leaving homes that would be neglect of home, or she maybe not rise to the level of Article 10, but clear the issues. So cross systems unit and Zalika has played a major role. She'll come in, and so I can't make a parent take the help, but I can suggest. And often when it comes in that message, we're not trying to follow, Article 10 matter, but there's services, and every Department of Social Services has services that you don't have to come to court to get. And that's been very, very effective because it allows us to give help to the parent and the other siblings while helping. Because often what happens is you'll see these young people come to court and a parent can feel that, why is she getting all the help? And I've said that when I really need to have the help. So the mindset.
Right. Thank you, Judge. And now for everyone who has been eagerly awaiting the second code is flute, another musical instrument, F-L-U-T-E, flute. As everyone takes a moment to write that down, I'm just going to peruse the questions very quickly. Quick question, Judge, that I don't want to save to the end, Judge Davidson, is have you kept track, or is there a way to talk about the recidivism rate for any of your participants in the grip court, or is it too young? We should mention that you soft launched this only about 18 months ago, if my timing is correct.
It's correct. It really is too soon. Have we had the issues, like I said, maybe be successful in a residential treatment, come back home, and then have to go back in. So it's a little too soon, and maybe that can be the second project by NYU. Because I think we do need to talk about that, because it's getting the girls to where we need them to go is much more, it's intense. So it's a little too soon to really have concrete numbers on that.
Great. So I want to move on to lessons learned. What can you share with us about this work? Do you have any particular lessons learned that you can share? And one question that I've asked you in forums like this before, and I'm going to ask you again, is have you had to change the way you think about a case that comes before you in the context of your training and being trauma informed and gender responsive to the girls that come before you in court?
Yes, it has. As for me, I feel I really look at the young person before me, wanting to know how she got there, versus focusing on what the charge is, what was in the petition, why did you do this, stop being so black and white as an attorney. Obviously it is a court proceeding. Obviously I'm not a social worker and all these things, but I realize unless I understand how she got here or he got here and what's happening at home, I'm not going to be able to be successful on the other end. And so it takes, and the commitment, and I think sometimes as judges, you want to kind of do the whole thing yourself, but if you don't have community involvement and really trust your partners, so that's a big lesson. And I think that sticking with it, because it was very hard work. We didn't have the benefit of the movement, even though I grew up under the movement. So it was kind of like, why is she talking about this again? Why is she bringing, the rolling of the eyes or things like that? And so the long haul. And I think for many of you, if you tried to start this, a grip court, but your format, why this? Why can't they just go to school? The lessons learned, it's deeper. And I think that's the benefit of this coming out now in this climate. It's a much deeper issue.
If I could add to that and seek your comment on it, one of the core participants in your executive team, Robin Carton, the attorney for the child, who is, I believe, participating as an attendee on this forum, one of the things that she mentioned early on that resonated is that how important it is for, while you're all collaborating, but how important it is for everyone to stay in their lane and do their job. Do you have any thoughts on that?
And it's absolutely true. When I get ready to talk to the children, I look at the attorneys and say, do you mind if I have a conversation with your client? Because if I can be the best judge I need to be in that moment, if Robin Carton, Jasmine Hernandez, Maurice William, the best AFC, if they advocate, as everyone does their role, then that creates the best solution for that young person before us. As Rashida Cartwright looks through those petitions, say, this is a young person. She has to do what she has to do in that moment. But knowing I have a person in a mindset that, okay, at the end of this, judge, I'm ready, to join in the application to dismiss this matter. So I can't be the AFC, even though I loved being an AFC. But if everyone does their job, it gives us the tools to make a better outcome for the children.
Well, that's a perfect segue into my next question, Judge. What constitutes success, and what constitutes a good outcome? Has that changed over time, or has your thought on what that is changed?
That's a question that our core group has been talking about, because success is so different in every single case. In one case, it was a young person leaving with her grandmother and going to Los Angeles to live with her brother, not being with her mother. Because, the premise of family court initially is to reunite the family. Another young person realizing, if I go back home and to my mother, then I'm not going to be able to I'll slip back into drugs. And so the option for me is a group home, still visiting. So success looks different in every different case. And that required for me to have a growth within me, that maybe this child back at home with mother, father, or whatever the situation may not be the best outcome. It may be what we see, and maybe we as a society have to look at what is the best for this child to be successful. And we know, especially children and people of color, and I'm standing here as a child of the dream, the educational piece, the community piece, and the opportunity. And sometimes the opportunity, unfortunately, is just not there at home. No fault, because this is layers and layers and layers of racism. But success in each and every situation is going to be different.
And I think, just to put a fine point on that, Judge, I think you nailed it, because so much about what we've learned about this work and about girls engaged in the system is that they really need individualized services, plans, outcomes. And I think we have spoken about this, and I think you've mentioned this at one of our other presentations, is that, your initial thought of success would be that everyone who comes through grip court is gonna, graduate with an A and go to college and become a doctor. And that's, that piece of it is what you just said in terms of nailing what an actual individualized good outcome is, perhaps was hard for the team to wrap their head around.
Exactly, because, if they have a goal to be a tattoo artist, who am I to say? At least I've looked at it as, but that's the goal. Now, maybe that's not going to be what happened at the end of 4 or 5 years, but, and that's just listening to the youth. That's where they are right now. I said to one person, I said to him, well, what do you want to be? He says, I just don't want to be a criminal. So that's a start, so you're right. What is success in him no longer imaging himself as a criminal and wanting, so. Exactly right.
Great. Well, I want to thank you, and we are getting ready to take questions. We have a fair amount of questions coming in that I will sort through in a moment, and I would also invite, I think some of them, just scanning them quickly, some of them might be also appropriate to address to Dr. Javdani again, so I will invite her back into the conversation as well. But just in terms of the work of the commission and the statewide angle of the three-pronged approach that we talked about, and that Judge Peters outlined in the beginning for us, the commission at our last meeting, heard about all this good work and was extremely supportive of it. And the response was pretty much, why can't we get this in all of our family courts? And that's basically what the commission now is working towards. I can share that the commission and the unified court system has submitted a joint application once again with the department, the Division of Criminal Justice Services for another grant, federal grant surrounding this issue. And what we would like to do with it is really dig in on the training aspect, and with the lofty goal of getting all of our family court judges trained, trauma-informed, gender-responsive, not only the family court judges, I should say, but all the stakeholders within family court, the AFCs, the presentment agency attorneys, social workers, anyone involved in the courts, just like Judge Davidson's team, to get them the same or similar training that that the Westchester team went through, so that every girl who walks into any courtroom across the state would have the same benefit that a girl would have, or a boy walking into grip court in Judge Davidson's part. So that is the goal, and I share that with you. And if the grant is not successful, we will be looking for other ways to get that accomplished. So that is our commitment as a commission to you within the state. I'll put this up. Should you have any further questions after we end today, that's all of our contact information. And I'll start going through some of these questions. We have a question: how can we get involved? That's a phenomenal question. And I open it up to Judge Fisher, Judge Davidson, or Dr. Javdani to answer or convey some thoughts.
Well, I would say, I don't know if you mean exactly the court, but I do think, depending upon where you are in your own life, if this is, I think you first have to have an understanding of the lives, if you're not a person of color, just on your own, sort of exploring into this area. I think any kind of support to a young person, wherever you're back, I don't know if you're a lawyer, whoever the question came from, but it would look at where do you, the crossroads of where you intersect in the world of institutionalized racism. That's where you begin to do the work. So for me, I became involved where I was as a judge. So wherever you are, we already know statistics show us, and the data shows us, wherever you are, there's going to be the disproportionality of effect on color, and begin to dig there.
Okay, another question. It's a multi-part question, but I think they're all related, so I'm going to ask them kind of consecutively. Regarding the services in grip court, we noted that there was a dispositional court. So the services that you talk about, those individualized services for each individual respondent, would those services be considered voluntary, or how do you get the girl to engage? And how do you reconcile your outcomes with the least restrictive environment analysis? Well,
so at the dispositional phase, after you've done you have a report from probation, a recommendation, you have some sort of report, a psychological report. So you're first guided about what the information comes back to you. And so at that point, to a certain extent, some things are voluntary and some things aren't. At the dispositional phase, it's the same as in a criminal matter, the sentencing phase, where the person's on probation. So, as to the least restrictive placement, again, it goes by the facts. What's available at the time. Sometimes going home isn't safe. It depends on what's available. Maybe it's living with a relative. But those services, the difficulty in terms of providing services up front, and that's why the Rosebuds is so phenomenal, because they're able to be assigned right at the very beginning. They sit with that youth right from the beginning. That's why a court-appointed social worker is very effective, because a court-appointed social worker can be appointed from the very first day. And that social worker can do an assessment of the family, they do an assessment of the young person, begin to inform me and everyone around us at that table what's necessary. So that's what happens at the discipline. Again, you're guided by the information I get, whether it's from the psychological evaluation, the home study that's done by the probation department. And then we begin to look at, for instance, if we see a young person who very much wants to be a teacher, then we go to our sororities and say, we have this person who's a teacher who's willing to, as I say, that's a huge part of sororities, specifically of sororities of color. We'll connect that person to provide it's being consented to by the parents. So it really flows from what's happening after we get the information at the dispositional phase.
Great. I open the next one up to all three of you. One of the challenges to many of these things is that there are often long wait lists for services. And is there a way to kind of overcome that, or has that been an issue? And to coincide with that is, are there opportunities taken to tie into Office of Mental Health Services or OPWDD services, which historically or could be overlooked as an outlet to help the families and the youth?
Yes, and part of our, I'll just briefly, part of our big stakeholders group, our Office of Mental Health was actually part of our stakeholders group, so we do include them.
I think sometimes the issue is a lack of services. I know especially in the rural counties, and I think what you have to do is just get more creative and educate yourself, especially if you're an attorney representing one of these young girls, and try to find out what resources are out there, and use that expression, the squeaky wheel gets the grease. You know, you have to be persistent and really, you know, and know how to navigate the system. I mean, when you talk about OPWDD, I mean, that system, I mean, most lawyers have a hard time navigating that system, let alone expecting a lay person to navigate it. So I think really helping, finding those resources sometimes on your own might be that. And I mean, we go back to what someone said earlier about what we could do to help. And I know Judge Davidson said we're not therapists and everything, but we are, you know, we all started off as lawyers. I think everyone on this call did. And I always say this a lot, is you're an attorney and a counselor at law. You're also supposed to counsel people. I mean, we're not therapists, but we can counsel them on what's out there. That, and I also think it's important, especially with these young people, these young girls, is, you know, finding a way. When someone talked earlier about success, it's really about finding a way to empower them. I think that's the most successful thing, that they're empowered not only to speak their voice, to fight for their rights, to get their way through the system, to get an education, and to do whatever it may be in the future that they want, so that they don't end up back in the system again, or, you know, in trouble in another court down the road. But I really think in terms of resources, it's really a lot of investigation, especially in these rural communities. It's really hard to find some of these resources, and it might take a little ingenuity in terms of finding its outreach, such as just Davidson mentioned with sororities or other agencies that you could potentially tie into. And I think a lot of times it's easy for us to get busy, either as lawyers and judges, and get overwhelmed with cases, but to just step back and to think about what it is that really brought that person to the court, you know, really being a little compassionate, and again, being intuitive or ingenious in terms of trying to find out a way to get the resources that they need.
Thank you. I'm gonna, oh, sorry, go ahead, Dr. Javdani.
I just want to say that one of the things, you know, Judge Davidson, you mentioned that some of these trainings and the learning community that you created, you know, supported a kind of transformative experience for you and for others who are doing this work. In my observation, one of the major aspects of transformation had to do with the lens of accountability and where it was placed. And this is in reference to your question, to the question that was posed around sort of what happens if there are wait lists, what happens if the services are not as compassionate as we want them to be, what happens if a girl misses a session and therefore comes back to court not having done the thing that she was asked to do, right? And I think that as part of the community of the grip court, the lens is shifted from thinking about, well, why didn't she go to the service? Why didn't she get done what she was supposed to get done? Or even, well, so I guess it was mom's responsibility or grandma's responsibility. Why didn't mom or grandma make sure that such and such thing happened, right?
Right.
But instead the lenses of the service. Well, what happened? Was there a wait list? Why wasn't it made available? It was our understanding that they were going to work with us and prioritize our children and families, for instance, right? Or why didn't she return? I don't know her to be a person who is just simply not going to come back. So was it an issue of fit around this service, right? As opposed to holding the child and her family accountable to just completing the thing that is available, that happens to be available, or even choosing among a menu of options that are all imperfect, right?
Mm-hmm.
And instead really looking at the service provider and saying, this is your job to provide this service, and this child and their family, they're a client of this service. Just like we would treat any other client, right, in a relationship seeking services, instead of saying, well, you've already messed up enough. All I asked you to do was go to these 2 sessions and you couldn't even do that, right? It's a very different shift in narrative. And I think that the kids likely can see that and can experience that difference and that difference in treatment. And it really has to do with whether you're holding the context and the response accountable, or whether the gaze is on the child and the family to hold them responsible. You cannot do the latter. You cannot hold the child and the family responsible when you have the lens of systemic racism.
And you know something, what you're saying is so right, because I think that what the movement is saying is, if you look at it, you're not looking at a Black man getting arrested and saying, well, if he would just calm down and did this, it would be okay. This is the time for us to say, we're not meeting the needs of Black and brown girls coming into court, period. What do we do as a community, whether it's legislation or whatever, need to address these needs? So we know this is happening, and I think that you're exactly right. We have to begin to step back and say, what are we doing as a court system? What am I doing with my friend who's a legislator, and say, let's talk about funding. What can we do to help address it? Because it's exactly right. It's the shift. It's the shift that you have to, and that's the purpose of all these training, because we have a tendency, it's the same reason when you don't want to look at, you don't want to say encourage, because Black girls are seen more aggressive and they have the attitude and the sucking of it, and that gets them in trouble. You're blaming this behavior as the reason. She just didn't suck her teeth, that she just looked and hadn't rolled her eyes. And so we have to be very careful that we step, and that's exactly why all of us went to all these trainings, so that no one look and say, there she goes again talking about race.
And I think that's a great place to stop. I know that there are additional questions coming in, and I apologize that we did not get to them, but I am getting the wrap-up signal. So at this point, I want to thank everyone for participating, particularly our panelists, and I'm going to send it back over to Judge Kretzer.
Thank you so much, Kristen. Let's have a huge virtual round of applause for Kristen and all of our panelists today. Thank you so much. I think everyone learned a lot. I know I did. I also want to thank our virtual host again, Albany Law School, and the Albany County Bar for the countless hours that Marquita has spent and will continue to spend getting out those CLE certificates. She asks that, given the huge number of participants we've had here today, that you understand that it may take until the end of July, which is certainly understandable. It's easy right now. Everyone talks the talk when it comes to racial justice, but I think that our key sponsors here, Albany Law School, Albany County Bar, the commission, the committee, my committee, we walk the walk by putting on programs such as this. I've had the privilege in the course of my 5 years as chair of the committee to help produce, to put on really 10 CLE programs on everything from sex trafficking to cyber harassment, animal abuse and the connection to DV. And I found that raising a public awareness through these programs has actually effectuated meaningful change in each of the areas where we've held CLE programs. I have a strong feeling that this program will do the same, that we will effectuate change, whether it's through expanding the GRIP programs throughout the state, which I'd love to see. We have something roughly similar in the Capital District area, brand new, called UCAN. I don't have the time to get into it. It's Judge Andra Ackerman sponsored it, but we should expand that and model it maybe a little bit on the GRIP courts for family court. This one is for criminal court. So wrapping up, I again want to thank each and every one of you for raising everyone's awareness, for teaching us so much, and now it's up to all of us to make a difference and effectuate it. Thank you all.